Welcome back to Good Law, Bad Law. Imagine driving down the highway and being pulled over by a police officer and having that police officer take cash or property that's in your car without even charging you with a crime. That might sound like the kind of thing that could happen in some other country, but it does happen in the United States of America, and it's called civil forfeiture. Worse, you could lose your house, you could lose your car, you could lose your property, even if you're not convicted or even charged with a crime. Well, thanks to a recent Supreme Court decision authored by Ruth Bader Ginsburg, there have been major changes in the law relating to civil forfeiture. And my guest on today's episode, Louis Rulli, a professor of law at the University of Pennsylvania Law School, explains the system of civil forfeiture, why this has been such a problem, including why this has had disproportionate impact on racial minorities in our country, and what the significance is of this new Supreme Court decision and how this could very significantly change how civil forfeiture is practiced around the country. It's a really important issue, one that isn't getting talked about enough, and that affects the lives of so many people. Stay tuned for this great conversation with Professor Rulli. Thank you. Welcome back to Good Law, Bad Law. On this episode, we're going to be discussing the Eighth Amendment to the United States Constitution, specifically the Excessive Fines Clause, something called civil forfeiture, which I'm sure a lot of our listeners have probably never even thought of, and Justice Ruth Bader Ginsburg actually rendering an opinion that was not a dissent, something that hasn't been true for some time, and a lot more. And to help us through what is going to be, I'm sure, a very fascinating and important conversation on this topic, I want to welcome my guest, Professor Louis Rulli of the University of Pennsylvania Law School, my alma mater. Professor Rulli, thank you very much for being on the program.
Well, thank you for inviting me. It's great to be here.
This is something I have to admit, I went through Penn Law, and I don't think I ever even heard mentioned the idea of civil forfeiture in our criminal justice system. So I'm not faulting Penn Law for that, but I thank you for being here. As it turns out, we were going to discuss this topic and had set you up as a guest to come in and talk about this. And while we were waiting to meet, as we're meeting this morning, Justice Ginsburg announced an opinion of the United States Supreme Court on this very topic that has completely changed the landscape when it comes to civil forfeiture. So we are either we had a crystal ball ahead in front of us, or our timing is just that good. So either way, I thank you for being here. And so tell us a little bit about yourself to begin with as we get into this topic, and how you yourself became interested in this, and how this has become an area of great interest to you in your work and your research.
It really has. And I think I'd like to just begin first with agreeing with you that most people have never really encountered or know about civil forfeiture. And when they do encounter it, their first response is, how can this be? Right. How could it be that the government can take my property when I haven't even been accused of a crime, for example? Yeah. So this was of great interest to me. I've been on the Penn Law faculty for 23 years, and about 20 years ago, in our civil practice clinic, in which we represent low-income residents, we began to see civil forfeiture. Philadelphia was a very aggressive hotspot for civil forfeiture. And so we saw people coming to us whose homes, cars, and cash were being taken by the government. And many of those individuals never charged with a crime.
So what exactly is it? Because you're right, that sounds crazy to me, and I think probably to most people. What is civil forfeiture, and when in the process of somebody first being accused of a crime or suspected of a crime, when does civil forfeiture, the taking of someone's property, actually come into play?
So civil forfeiture is when the government seizes private property and then in a civil action sues to permanently take that property, forfeit that property to the government based on the legal fiction that the property has done wrong, that somehow the property has facilitated criminal activity. And because the action is not against the property owner's guilt is not determinative of a civil forfeiture action. Civil forfeiture is a very powerful weapon. It existed at the very beginning of our country and was primarily used in the area of piracy, customs violations. You had these ships that were smuggling. The ships were owned by people in Europe. The way to get a handle on that problem was to seize the ships, the tools of the trade that violated the law.
The ship and everything on the ship.
And everything on the ship.
Yeah.
That's right. And the Supreme Court of the United States upheld that as constitutional back in the 1800s. But civil forfeiture, as we now know it, really began in frequent use in the 1970s and the 1980s as part of the war on drugs. Congress, wanting to go after large criminal enterprises, drug cartels, enacted legislation to bring civil forfeiture to the fight against drug activity. And again, it made some sense. If we could take away the tools of the trade of these large criminal enterprises, perhaps we could make some headway in the war on drugs. But one of the things that Congress did was it provided that all of the proceeds of civil forfeiture would go to law enforcement rather than state treasuries or the federal treasury or to other public purposes. And as a result, it created a profit incentive for law enforcement. And as a result of that, civil forfeiture became abusive, and it began to be used very heavily against ordinary citizens for relatively low criminal activity, but which placed their property directly at risk.
And when you say low-level criminal activity, and where the idea of this may have originated with wanting to target large-scale criminals, and when it comes to the war on drugs, large-scale drug traffickers. But you said this originally came to your attention through your work in the clinic, where you're representing low-income citizens who have some kind of a legal problem. That doesn't sound like the kind of individual who's a large-scale narco trafficker. That sounds like people who might have been caught, on a possession charge or something fairly low level, and yet they become vulnerable to not only losing the joint or the ounce of weed they have in their car, but also the car. Or even something else.
Yeah, and even more. We began to see homes being taken in Philadelphia in large numbers.
Wow.
From low-income residents, mostly in North Philadelphia, West Philadelphia. Very much race is a part of this, and maybe we can discuss that a little later. But, primarily civil forfeiture is used against homes, cars, and cash. And what we saw were grandparents who owned their homes. They were all paid up. They had very modest resources, and maybe their children, adult children, or even adult grandchildren, were charged with low-level marijuana or other drug offenses, usually $20 sales or something like that. And then what would happen is the district attorney's office would prosecute that individual, but then bring a civil forfeiture action and try to take the home of that grandparent. And we began to see those in 2000, 2001. And I'll give you one example, because it really stands out.
Right.
We had a 77-year-old woman from North Philadelphia. She was suffering from end-stage renal disease. 3 days a week she had to go for kidney dialysis. She left her home open because her neighbors helped her very much, and they would come, they would bring her food, they would really look after her. And one day the police chased a low-level drug offender, and this drug offender ran through her house. He obviously was from the neighborhood. He knew that, and he dropped the drugs that he was selling in her home.
Wow.
Well, they ultimately prosecuted him, but then they brought this action against her home to take the home of a 77-year-old woman who was never charged with any criminal activity, never suspected of any criminal activity. And we saw that and said, how could this be? Could the law really permit this? And so that began our journey into civil forfeiture.
I mean, you can't hear me doing this, but I'm shaking my head as I'm listening to this story. So how could they do that? How could that even happen?
Well, once again, under civil
Legally,
forfeiture, they
how does that
argued
happen?
that the House, the district attorney's office argued that the House helped to facilitate criminal activity, and therefore they could bring a civil forfeiture action. Now, did we think that was meritorious? No, not even under the Civil Forfeiture Act, even as harsh as that law is. But there is no right to counsel in a civil forfeiture action. So if you can't afford counsel, you're probably not going to have counsel. And fortunately for this woman, we had a service providing free legal services.
Through the law school.
Through the law school.
Yeah.
Through our students who were certified by our state and federal courts to represent under faculty supervision.
Yeah.
But we looked around. Nobody was providing representation in civil forfeiture. Why? Because it's not a criminal offense, so the public defender office wasn't handling it. And the local legal services program was not handling it because they were overwhelmed with mortgage foreclosure and landlord-tenant law and other kinds of civil problems. So this was really in the crack between the civil and the criminal process, with nobody getting help. And what we saw in Philadelphia, and which congressional hearings documented, is that so many of these cases resulted in default judgments. People did not contest. They didn't know how to contest, and they didn't have access to counsel.
Wow. And just to be clear, the reason they didn't have a right to counsel, and what we mean by that is a constitutional right, is because this isn't a criminal case. And the constitutional provision that provides that you do have a right to counsel only applies in criminal cases. Is that right?
Absolutely.
Okay.
The Sixth Amendment's right to counsel is only in criminal cases.
Okay.
And that the Supreme Court of the United States has not extended that concept to civil cases by and large. Now, we do have some exceptions. But in terms of the Pennsylvania civil forfeiture law, there is no right to counsel.
And so to go back to my earlier question, in the example you gave us, a crime had already been committed, and the perpetrator of that crime, however you want to characterize that crime, was charged and convicted. So the civil forfeiture action in that example followed the criminal conviction. Is that right?
That's right.
Okay.
Usually the district attorney's office would bring a civil forfeiture action 30 to 60 days after the arrest, but many times before a person is actually convicted of a crime. And again, because civil forfeiture doesn't require the property owner to be charged with a crime, that criminal proceeding is separate entirely from the civil forfeiture action. That
part seems really that part seems to present due process problems for me. I can imagine a rationale that especially if you think of another example, not a 77-year-old woman who's really innocent of any connection to the crime itself, as in the example you gave us. But if you do imagine somebody who's a big drug dealer and, is using the proceeds of his illegal drug activities to buy cars and rings and whatever, you can imagine a prosecutor, we have El Chapo who's just been, prosecuted in New York, saying, okay, we as the prosecutor's office have just spent all this money and time and taken all this risk and everything else that goes along with this prosecution. It seems right and fair that the ill-gotten gains, if you will, of that criminal activity should not remain in the possession of the wrongdoer. I can understand that from a lot of different perspectives. But in practice, it seems like this is a a procedure that's really run amok. And I do want you to talk about the disproportionate impact on not just low income individuals who don't understand the process, don't have access to counsel, and so on, but also the disproportionate impact from a racial standpoint, because I think that's really speaks to the unfairness of the system as we've known it until recently. We'll get to that too.
So you've raised a lot of good points here. And we can understand the notion of taking ill-gotten gains from big drug dealers. Yeah. And you use the example of El Chapo, and that's a great example. But this is where the law, in theory and maybe in intention, departs from the law in practice and in reality. Because over the last few decades, so much money is generated from civil forfeiture that it has become a funding stream for law enforcement. And in fact, what we see is that property in very small amounts is confiscated through civil forfeiture, and when aggregated, brings millions and millions of dollars to local authorities.
Do we have any? I see you brought some notes, and I'm grateful for that. Do we have any idea of the scope of the numbers we're talking about?
Yeah, let me start with Philadelphia first, and then I want to talk about South Carolina.
Okay.
This is a national problem. It's not a local problem. It's everywhere. But just to give you a sense, we studied the problem for a decade, and I want to use a decade figures just to give you a sense. From 2005 to 2012, in Philadelphia alone, the law enforcement forfeited $28 million in cash, 1,697 cars, 670 houses, and a total income from forfeited property of $39.32 million. Wow. That's just Philadelphia. Incredible. So that gives you a sense of how what has happened is as there's been a reluctance to raise taxes. Law enforcement has looked to other funding streams, and costs and fees, which is, I think, the next big issue. Civil forfeiture is a part of that. It has become a very lucrative funding stream, and it has fueled more and more abuse in the bringing of civil forfeiture against ordinary citizens, low-level offenses, and in ways that prevent folks from really fighting back.
And when you say the money goes to law enforcement,
yes.
I mean, we're talking about to the police.
Yes, to the police and to the district attorney's office.
Okay.
Yes. And in Pennsylvania, 100% of the proceeds go to law enforcement.
Now, do we know anything about if almost $40 million in that time period that you told us about? Do we know anything about the demographics of that money? Where is it coming from? And is there a racial component there, or an impact that disproportionately affects minorities, African Americans, Hispanics? Any details on that?
Yes, we know that it's very closely aligned with race. In Philadelphia, we studied that question in home forfeitures, and we mapped out every forfeiture, and it maps very closely to the areas of the city where the highest minority population exists, primarily African American, but also Latino. And what we also mapped out was the fact that in all of the expanded center city area, which is primarily white, there was only one civil forfeiture action brought in the, we studied a particular year in which there was a high level of forfeitures, and only one involved the expanded center city area, and that one was against an African American family. So it's, but apart from Philadelphia, in South Carolina, the Greenville Press just did a 3-year study, which has been in the news lately, and what they showed was that in those 3 years, black men in South Carolina make up 13% of the population, but they were 65% of the victims of civil forfeiture. Wow. So, and we see that all around the country, that race is very much a part of civil forfeiture. African Americans are more likely to be stopped by police because of stop and frisk policies. and they are much more likely to see their property seized and ultimately forfeited.
Well, I kind of dropped to this point, but I want to come back to it again. In the example you gave us of the homeowner, the grandmother who lost her home.
Well, she didn't lose it because we successfully
Oh,
represented her.
Okay, well, she nearly lost it until the Penn law students came in and provided her assistance. Can forfeiture be imposed even before there's been a conviction for a crime?
Yes. And again, it's an in rem proceeding. It's a proceeding brought against the property. It's not an in personam proceeding that's brought against the individual.
Yeah.
So therefore, it doesn't rely upon a conviction, and it doesn't even require a charge, an arrest. If property facilitates, in the opinion of the law enforcement agencies, a crime, it can bring a civil forfeiture action. Let me give you where most ordinary citizens are coming across civil forfeiture. They're driving on the highway. They're stopped for an alleged traffic violation. Maybe there's a light bulb is out, or we see a switching of a lane without providing a signal. They're stopped. Their car is searched, often with the permission of the owner, and cash is found. The cash will be seized by police authorities on the theory it must be drug money. And there's no charge. In fact, it got so bad in Texas, in Tanana, Texas, which was very much in the news, the police would have signed releases on the spot saying, we will not charge you with any offense if you agree to give up your property and you sign this release. That was challenged in the courts, and for the most part, those releases have stopped. But we do see in various spots this arise again and have to be challenged. But definitely right now on the highways, we're seeing a lot of cars and a lot of cash being seized. And because it is such a enormous funding stream for law enforcement.
So you could be stopped for a taillight and have money in your glove box, and the police would take the money and not charge you even with the citation for the taillight being out. They just stop you and take that's.
They could charge you with the traffic violation, but they often don't. They take the cash and they let you go on your way without your cash, and then it's up to you to try to fight back to get that cash back.
That sounds like the kind of thing that might happen in some other country.
Right.
Where you might feel nervous about being pulled over by the police, but that just doesn't sound like the kind of thing that could happen in our country, but it does.
Well, I think it's been under the radar for so long, and I think now, and this really leads to the Supreme Court, there's been much more focus in the courts as judges have become educated about what's going on the highways in particular, and in localities that they're really taking a much harder look at civil forfeiture. And Justice Thomas, for example, authored an opinion last year in a case in which they denied review in a civil forfeiture case, but he took the opportunity to write separately and say, we really have to look at civil forfeiture. Is it out of step with the history of this country? Is it a violation of due process? Is it something that really just doesn't comport with our system of justice?
Well, again, we're bringing up the idea of due process, and before we get to the Supreme Court case that just came out a few days ago, what arguments did you use to win back the house for this woman who had nothing to do with the crime that just incidentally happened in her house? What were the legal arguments against her house being taken?
So there are three really good defenses that, if you have counsel, could be raised. Number one, it is the burden of the government to show that there is a nexus between the property and the criminal activity, the crime. In that case that I pointed out, that nexus was very tangential. This wasn't a situation where people were showing up at the house and it was a crack house or something like that.
Right. And where the owner knew that it was being used as a crack house.
Exactly.
Yeah.
Which brings us to the second defense, and it's a statutory defense, and that's called the innocent owner defense. If the owner can demonstrate that he or she either did not know of or consent to criminal activity in the use of their property, that is a very powerful defense. It puts the burden on the property owner to prove their innocence, which has been much criticized. The burden should be on the government. But nonetheless, that's a defense, and we use that defense regularly. And then the third defense is the constitutional defense. And that is that we do have a ban on excessive fines in the Eighth Amendment to the United States Constitution, and we have a similar provision in the Pennsylvania Constitution. So we asserted all of that as well to protect the homeowner.
Well, I think actually that does give us the perfect segue into this case then, because the issue of the Eighth Amendment applying at the state level is exactly what Justice Ginsburg resolved in 2019. We were talking about this before we started. It's one of those cases that when I read it, I thought, wow, how is it we've gotten all the way to this point in our country's history and we didn't have this question answered until now in our law? But perhaps people have heard of the Eighth Amendment to the Constitution more familiarly because of the cruel and unusual punishment provision of the Eighth Amendment. And I'm willing to bet most people have never heard of the excessive fines clause of the Eighth Amendment, but that is the language in the Eighth Amendment that's at issue when it comes to civil forfeiture, and that was at the heart of Justice Ginsburg's opinion in this case, called Timbs versus Indiana. So first of all, what is the excessive fines clause, and then perhaps you can use that to set up what the controversy was in this case.
Okay, sure. I mean, you're absolutely right. Most people haven't heard of the excessive fines clause. There's 3 clauses in the Eighth Amendment, and most people are familiar with the other 2 clauses, the cruel and unusual punishment clause and the bail clause.
Yeah.
And the Supreme Court has spoken to those 2 clauses regularly. But with respect to the excessive fines clause, a ban on an excessive taking by the government when it's grossly disproportionate to the gravity of the criminal activity is something that the Supreme Court only first spoke to in 1989, quite late in our history. And so the question that was before the court in this case, and maybe I should mention the facts first because I think that will help.
Yeah.
So Mr. Timbs lived in Indiana, and he had a Land Rover that he bought he bought it legally with funds that he obtained from a life insurance policy when his father passed away. The Land Rover was worth $42,000. He was accused of a crime, low-level crime, that he pled guilty to, of selling drugs with a street value of less than $400. Under Indiana law, the maximum fine that could be imposed was $10,000. In fact, he was only fined roughly $1,000.
Right. The opinion says it was $1,203.
Yeah, something.
Fees and costs.
Right.
Yeah.
And so the question was the taking, when the government sought to take his Land Rover for this low-level offense that was worth $42,000, was the taking of property worth $42,000, more than 4 times the maximum criminal fine that could be imposed? Was that an excessive fine in violation of the excessive fines
and
clause?
400 times the fine.
That was actually imposed, and more than that for the amount of the drug value of this low-level offense.
Right.
And again, and so many of these offenses involve marijuana, which is legal now in so many jurisdictions. So the lower court in Indiana said, no, this is grossly disproportionate to the gravity of the offense, and we will not permit the taking of his Land Rover for this offense. But it went up to the Indiana Supreme Court, And the Indiana Supreme Court said that the Eighth Amendment's excessive fines clause does not apply to Indiana, to the states. And so that question went to the United States Supreme Court, which had never decided this question. It had decided most of the Bill of Rights had applied to the states through the 14th Amendment's Due Process Clause, but it had never ruled on this particular clause.
Well, let me ask this, and I don't know if this will be fair or not, but I mean, do we know what at our country's founding was behind this? Why is this part of the Eighth Amendment? Why was this made part of the Bill of Rights in the first place? You talked about piracy, back in that time. Do we know anything about why this was included in the Eighth Amendment?
Yeah, we do. Justice Ginsburg really did a deep dive in this opinion to go through the historical analysis, both in England and what we inherited from England in our system of justice, and in the early concerns of our founding fathers in setting up the Bill of Rights. And so there was a lot of concern in two ways: that excessive fines, if you will, by the government was used to retaliate against unpopular speech. And we saw a lot of that, and so it was important to rein that in so that it was not permitted. And then second, it was used as a funding stream. Rather than being used for penal purposes, it was being used as a funding stream. So both of these things were intended to be curtailed by an excessive fines clause. And we see it in the Magna Carta, that you can't take away the livelihood of a person through these means. So Justice Ginsburg did a very good job in developing the historical analysis, why it's so important to our system of justice, and then bringing it current to today's world.
And to incorporate this part of the Eighth Amendment through the 14th Amendment now means that states like Indiana and South Carolina and anywhere else in the country can't rely on that argument anymore to say that, hey, we can do whatever we want here. We can impose what on its face looks like it is an excessive fine because the Eighth Amendment doesn't apply. They can no longer make that argument. So what is the impact of this now going forward?
Well, this is a very strong opinion. First of all, it's unanimous, as you pointed out, and we don't get that many unanimous decisions out of the U.S. Supreme Court. It's a strong signal to law enforcement that courts will be much more involved in scrutinizing the taking of property, and it will pump more life into the excessive fines clause. Hopefully lawyers, when they're representing individuals whose property has been taken, will be asserting this defense. This is an affirmative defense. Constitutional defenses, they can be waived if they're not raised, and so they need to be raised. And I think, number one, the bar and courts have to be educated about the excessive fines clause. Still to be determined, and the Supreme Court didn't speak to this in this opinion, is how will we measure this gross disproportionality between the value of the property and the gravity of the offense? This is ahead of us. The Pennsylvania Supreme Court has issued, I think, probably the most progressive decision in the country on this question. But local federal courts are going to be looking at this, I think, much more closely in the years ahead.
Well, tell us about that. That's fascinating. Tell us about that Pennsylvania Supreme Court case. How did they wrestle with that question?
So they were looking at the taking of a home forfeiture. And the analysis that existed in Pennsylvania was very simplistic. It was, how much is the home worth, and what's the maximum fine for the offense? And for many drug offenses in Pennsylvania, the maximum fine can easily be $100,000, even though that's not the fine imposed.
Right.
But the value of Philadelphia homes, on average, is actually, $40,000 or something like that. So almost per se, the value of homes just was not in excess of the maximum fine that could be imposed, even though those fines were not being imposed. And so to simply reduce the excessive fines clause to a binary choice between those two values didn't make sense.
Okay.
And so the Pennsylvania Supreme Court said that we had to take a much closer look at this. Number one, to require that we look at whether or not the property was the instrumentality of the crime. If it wasn't, it violates the excessive fines clause. If a court finds that it was the instrumentality of the crime and not just tangential, then it has to look at a more subjective look. We have to look at what's the value of that home, for example, in terms of disrupting the children's education if they lose that home? Will it drive people more into poverty and disrupt their ability to put them on public roles and the like? So it's a much more comprehensive look and not simply at just a couple of figures. And we saw those questions being posed in the oral argument in the United States Supreme Court in the Timbs case. We saw questions being posed, would it matter whether the person was rich versus poor? Would it matter whether the property was a new car versus an older car? But the Supreme Court of the United States left those questions for another day, and really, I think, for states to develop. And so Pennsylvania may be in the lead on that, but we're going to see a lot more state Supreme Court decisions.
Well, this was another, I wanted to ask about this too. This is another interesting detail of that Timbs case, the case that Justice Ginsburg decided. You described how the state imposed this fine by essentially confiscating Mr. Timbs's Land Rover. But in the description of what happened, it's also noted that the state hired a private law firm to bring the civil forfeiture action against Mr. Timbs. Tell us about that, because we talked earlier about the fact that a lot of people who don't have the means or don't have the experience or for whatever other reason don't know what to do in this situation, they simply do nothing and lead to a default of their car, their house, or what have you. Here, the state is actually hiring outside private law firms to bring these cases, which to me seems to stack the deck even more so against these individuals. So what do you know about that?
Yeah, I definitely agree. So it was shocking, actually. State law in Indiana permits the hiring of private counsel on a fee contingent basis to go after property.
Yeah.
So
to get a piece of the
to get a piece of the action, if you will. It accelerates the profit motive behind here. And decisions about whether or not government should be taking property should not be in the hands of private counsel whose compensation will depend upon getting that property regardless of the facts of the case, right? So that's a very troubling provision in Indiana law. Now, that does not exist in all of the states. Okay. It does exist in several of the states, and I think at some point in the future we will see that directly challenged, and it'll be interesting to see whether or not the courts will uphold that.
Well, I imagine that part of what you're hoping comes from this Supreme Court case, and again, perhaps the notoriety that Justice Ginsburg has, almost cult-like status these days, and as the author of this opinion, maybe it gets an extra amount of attention because she's the one. And as you say, it is a unanimous decision, which we don't see very often from what's otherwise a fairly divided court. But I imagine that part of what you are hoping for out of this is just greater attention to this issue. Again, I didn't even know this existed until till I read about it in that South Carolina newspaper. And so more people knowing about this, greater awareness, greater education, more people can do something about it if they face this type of situation.
It really does begin with education.
Yeah.
We have to know about the problem before we can solve it.
Right.
And so if we can get more light to be shined upon the problem, I'm optimistic we're going to make real headway. And we are beginning to make headway because now 29 states over the last several years have enacted changes to their state civil forfeiture laws because these abuses have come to the attention of state legislatures. So we're going to see some reform through the state legislatures. We're going to see reforms through the courts as there's more scrutiny. The unanimous opinion of the Supreme Court tells us that both the left and the right agree, maybe not for all of the same reasons, but agree that criminal justice reform needs to go forward. And a part of that is looking at civil forfeiture and reforming and taking away some of this profit motive that is fueling this abusive practice.
Well, and it's the unfairness of it, and it's the disproportionate impact on those who are already vulnerable in our criminal justice system and in our legal system generally, that to me is particularly disturbing about it. So I want to just, this will be the ultimate softball question to
Okay.
you, but the fact that you came to this through your work at the law school clinic, where law students get to really practice being real lawyers by taking on cases like this on behalf of people who wouldn't otherwise have access to an attorney, says a lot about the potential for really helping level the playing field here. I mean, nobody's saying civil forfeiture shouldn't exist at all. There is a reason and a rationale for it, but it should be administered fairly, and those who are the most vulnerable shouldn't be treated so unfairly in the system. So I wonder if you want to call out to your colleagues at other law schools and say, hey, this is a great kind of learning process for law students, and most law schools have clinics where law students can practice in these kinds of cases. These are the kinds of cases, it seems, where you can really make a difference in somebody's life, as you and the Penn Law students were able to make in the example you gave us of that woman in Philadelphia who had nothing to do with that crime and was facing the loss of her home.
Well, we've done this for over 15 years, and you're right. For clinics, it's a win-win situation because students get to do actual representation where it matters so much to individuals who wouldn't have access to resources otherwise. So, at the same time, it's really advancing their own professional development and education. But I would point out as well that it's not just low-income folks. What we're seeing in civil forfeiture is that small amounts of cash is being taken by government authorities. For example, in South Carolina, in this study, 55% of the time, police seized cash less than $1,000. Now, even if you can afford counsel, it doesn't make economic sense to pay counsel to get that 1,000 or less than 1,000 back, because it's going to cost you more.
Right.
So,
and you're probably intimidated in that moment and thinking, okay, I don't want to lose $800, but I don't want to be charged with the crime either.
Right.
So, I mean, that's a very...
Intimidation's a big factor here.
Yeah.
And that's why there's such high default rates in civil forfeiture. When Congress studied this problem and held hearings, they found that upwards of 80% of the cases resulted in default judgments.
Wow.
And that tells you, number one, there needs to be a right to counsel. It tells you that really nobody should lose their property if they haven't been convicted of a crime. There's something fundamentally wrong with our system of justice if property is being taken where we're not even charged or convicted of a crime.
So that kind of reform would have to take place at either the federal level, through some federal legislation that then could be applied across the states, or on a state-by-state basis.
That's right. And there are attempts to reform both federal civil forfeiture law as well as state laws. And as I mentioned, many of the states now are beginning, at least at the margins, to make some changes. Some states are taking the money away from law enforcement and saying it's got to go to the general treasury or to education, other public purposes.
Which takes away the incentive to engage in this practice if you're a state trooper or a police officer stopping someone on the highway.
Exactly.
Yeah, okay.
I mean, we've seen terrible examples of where people get bonuses because they bring in more civil forfeiture money. So you can see how it really can distort the important purposes that law enforcement has.
Wow.
So there's a lot of work yet to be done, but I think the Supreme Court decision in Timbs v. Indiana gives us real hope that we're focusing on this now. And there's a lot of movement, I think, around the country. And so I think we're going to see some good developments.
Fantastic. Well, Professor Rulli, Lou, thank you so much for coming in and for educating us on this important topic and for being part of Good Law, Bad Law. Thank you so much.
Thank you for having me.